Dr. Aswe Ighodalo, on 17th of April 2025, filed an appeal to challenge the judgment of the Edo State Governorship Election Petition Tribunal that upheld the election of Senator Monday Okpebholo as the duly elected governor of Edo State. Senator Okpebholo and the APC have also filed their reply to the appeal by the PDP. In this special report, our senior reporter, Best Orator, will highlight the prayers or otherwise of the petitioners and the respondents.
I want to thank God Almighty that made this possible. We also want to thank the good people of Edo who voted for us. This is not a news to us, because Edo people have spoken before. The court has just reaffirmed what Edo people voted for. So we want to thank God, we want to thank the people of Edo. And I also want to congratulate my principal, the executive governor of Edo State.
Monday Okpebholo is the governor of Edo State. He was elected by Edo people. And we are using this opportunity to call on everybody in the state to come together at this point.
This is victory for Edo people. This is victory for democracy. And we have confidence in the judiciary in delivering justice.
On Wednesday, 2nd of April 2025, the Edo State Governorship Election Petitions Tribunal dismissed the petition by the People's Democratic Party and its candidate, Dr. Aswe Ighodalo. The panel, headed by Justice Wilfred Kpochi, had said that the petitioners failed to prove the alleged overvoting and non-compliance to Electoral Act. It is based on that judgment that the appellant in this instance, that is the PDP and Aswe Ighodalo, have approached the Court of Appeal here in Abuja to challenge the outcome of the tribunal judgment. In this special report, our focus will be to highlight the prayers or otherwise of the application by the appellant and also the prayers of the respondents in this petition. So sit back and enjoy this special report. The appellant, PDP, and Dr. Aswe Ighodalo are appealing the judgment of the tribunal on two grounds. The issue for determination is whether, having regards to the pleadings of the parties, the applicable laws, and judicial precedents, the tribunal was wrong when it rejected the oral and documentary evidence led by the appellants as proof of the facts of non-compliance with the provision of Section 73(2) and 51(2) of the Electoral Act 2022, and in holding that the appellant did not prove grounds 1 of the petition, and whether, having regards to the pleadings of parties, the quality of evidence led by appellants, and the state of the law as laid down by the Supreme Court, the tribunal was wrong that the appellant did not prove their case of collation of incorrect scores and exclusion of results of 96 polling units, and that the appellants did not prove ground 2 of the petition. And whether, having regards to the pleadings and upon proper evaluation of the evidence and the correct application of the law, if the tribunal was right when it dismissed the petition. Also, the case of the appellants is the issue of pre-recording in Form EC 25B as prescribed by the first respondents INEC for compliance with the provisions of Section 73(2) of the Electoral Act does not contain the serial numbers and other particulars of result sheets, ballot papers, beavers machines, and other sensitive electoral materials in 378 polling units. The appellant said the complete absence of the record in Form EC 25B in 378 polling units was indicative of total non-compliance with Section 73. The PDP in the appeal said the Forms EC 25B not only manifestly showed that no serial number of any sensitive electoral material was entered in them, but claimed that it was also the case of the respondents through their cross-examination of appellant witnesses that the serial number of sensitive electoral materials was not entered into Forms EC 25B. According to the PDP and Aswe Ighodalo, the tribunal failed to appreciate that the Form EC 25B were the statutory records of compliance and non-compliance with the provisions of the law. It said the tribunal also failed to appreciate that the tendered exhibits were in themselves admissible in evidence in proof of whether there were prior recording in the forms prescribed by INEC of the quantity, serial numbers, and other particulars of results, ballot papers, and other sensitive electoral materials. Referencing the case of Okoye versus Charles and others, the appellant said the tribunal was clearly wrong to hold that the oral evidence of the witnesses who were present at the polling units were necessary to prove non-compliance with Section 73, subsection 2 of the Electoral Act. They maintained that the certified true copies or original of INEC documents which manifestly disclosed non-compliance having been rendered as sufficient proof of non-compliance in Section 137 of the Electoral Act and an exception to the hearsay rule as codified by Section 38 of the Evidence Evidence Act 2011. On issue 2, the complaints of the appellants in ground 2 are under 4 subheads, which are as follows: alleged collation of incorrect scores in 125 polling units, that the collated scores on Form EC8B not predicated on any of the Form EC8A in 10 polling units, collation of results on Form EC8B that are not derived from any Forms EC8A in 101 polling units, and the exclusion of results from 76 polling units of Ikubaka local government area. They claim that none of the respondents meant the appellant's case on ground 2 in the evidence presented before the tribunal. They said the issues before the tribunal were whether there were collation of incorrect scores and exclusion of or failure to collate the results that duly emanated from the disputed polling units. The summary of the reason upon which the argument is founded and conclusion according to the PDP and Aswa Ighodalo is that 13,344 votes are liable to be deducted from the scores of the appellant as contained in the Form EC8D, and also claimed that 55,279 votes are liable to be deducted from the scores of the second and third respondents in Form EC8D. The PDP in the appeal said that the collation of correct and lawful scores of the parties using the certified true copies of Form EC8A uploaded to IREV shows that the correct and lawful scores of the appellants in 312 polling units under the grant of the petition is 16,651, and the correct scores of the second and third respondents is 12,338, alleging that the correct and lawful votes is 243,113 for the appellants and 210,326 for the second and third respondents, indicating that the appellant won the election with a margin of 32,787. In reply to the appeal, the respondents urged the appeal court to dismiss the appeal of the PDP and Aswa Ighodalo for lacking in merits, and particularly because 1. that the tribunal duly considered the pleadings and properly evaluated the evidence adduced by parties before coming to the correct conclusion that the appellants failed to prove their petition against the respondents. 2. that the findings and conclusions of the tribunal are sound and proper, as clearly borne out by the evidence on record before the court. 3. that the appellants have not placed anything before the appeal court to suggest or show that the decision of the tribunal are erroneous or perverse in any way as to warrant the setting aside of the judgment. The respondents, Senator Monday Okpebholo and the APC, wants the appeal court to determine whether the tribunal was right when it arrived at the conclusion that the petitioners failed to prove substantial non-compliance as pleaded by the petitioners, such as to warrant the granting of the relief sought by the winner of the Edo State governorship election held on September 21, 2024. They also want the appeal court to resolve the issue for determination in the affirmative and to dismiss the appeal in its entirety as lacking in merit, and it is important for the court, according to them, to begin by pointing out that the ground 1 of the appellant's petition before the tribunal was predicated on the complaint of non-compliance with the provision of the Electoral Act. The respondents listed the following reasons why the appeal court should dismiss the application by the PDP and Dr. Aswa Ighodalo as follows. 1. that the documents tendered by the appellants from the bar to prove the alleged non-compliance were dumped on the tribunal and were of no evidential value, as the appellants did not call any competent witness to tender, demonstrate, and relate the document to the aspect of the appellant's case. 2. that the PW1 to PW14 of the appellants, not being polling unit agents and not being persons present where the polling unit booklets were filled, were strangers to the document who were incapable of giving direct eyewitness evidence to demonstrate and link them to the aspect of the appellant's case. 3. that the polling unit booklets tendered by the appellants were doubtful provenance that cannot be relied upon because they were incomplete, consisting of only 7 pages each instead of 9 pages, and there were no explanation for the missing 2 pages on each of them before the tribunal, which the petitioners and the appellants failed to adduce. 4. that in the face of the doubt raised by the missing pages of the polling unit booklets, the appellants were duly bound to call polling unit agents or other persons who were present at the polling units and witness alleged non-compliance to adduce direct eyewitness evidence before the tribunal, which the appellants failed to do. 5. that the provisions of Section 137 of the Electoral Act 2022 does not avail the appellants the circumstances in this case and does not relieve the appellants of the burden of proving their petition petition to the satisfaction of the tribunal as required by law. 6. That the evidence of PW1 to PW14 is hearsay evidence and is of no moment since they were nowhere near the polling units during the election, and that even the 5 polling unit agents PW15 to PW19 called by the appellants did not say a word concerning the issue of non-prior recording of the serial numbers of election results, beavers machines, and other election materials which form the main complaint in ground 1 of the petition. 7. That the evidence elicited during the cross-examination of the PW2, PW3, PW4, PW7, PW8, and PW12 of the appellants negatives and contradicts the case set up by the appellants that there was no prior recording of electoral materials as prescribed by Section 73(2) of the Electoral Act 2022 before the election. Number 8. That the biomodel voter accreditation system beavers machine, which were tendered from the bar and were not activated or open for their content to be demonstrated before the tribunal, were of no avail to the appellant to prove the alleged overvoting. They said the tribunal in this case properly reviewed the pleas, evaluated the evidence, and correctly applied the law to the fact that they came to the right conclusions based on the existing and well-established precedents and authorities which is duly referred to. The respondents said the tribunal cannot be faulted for abiding and following established judicial precedents, however much the appellants may detest such precedents and finds them sour like a bitter pill to swallow. Okpebholo and APC said Section 137 of the Electoral Act does not and cannot relieve a petitioner of the burden of proving a petition to the satisfaction of the tribunal as required by law. They said the section does not also relieve a petitioner of the duty of trying each piece or bundle of documentary evidence to specific aspects of the petitioner as made out in the pleading. They said it still remains true that documents do not speak for themselves and holds the views that Section 137 of the Electoral Act has not abrogated the provisions of the Evidence Act to that effect. That even when the allegations of the petitioners relate to non-compliance, the petitioners must, through his evidence, expatiate on the nature of the non-compliance and its effect on the declared results of the election. They say the petitioners cannot, under the guise of Section 137 of the Electoral Act, documents on the tribunal without more and expect the tribunal to scrutinize them in the recess of its chambers in order to decipher the non-compliance complained of. They said the petitioners must first of all lead evidence of the alleged manifest non-compliance with the Electoral Act through its witnesses before the tribunal will then look at the document to see if the non-compliance is manifest thereon. They said Section 137 of the Electoral Act is not intended to transfer the long-age constitutional duties of the claimants or petitioners to prove his assertion by credible evidence to the court, as that will go against the Constitution and the rule of natural justice. They explained that there can be no doubt that the provisions of Section 137 of the Electoral Act 2022 is not a magic wand and has not absolved the appellants of the duty of calling direct oral evidence of polling unit agents and other persons who were present at the polling units to prove allegations of non-prior recording, overvoting, or other forms of non-compliance. The respondents said, contrary to the appellants' contentions, it is not correct to say that demonstration of evidence is something that should not be done in open court before the tribunal, or that demonstration of evidence is something that should be done in the addresses of counsel, perhaps by way of table or graphs contained therein. They said to the contrary, the law is well settled that demonstrations of evidence can only be done before the tribunal in open court during the trial. Citing the case of Ogboru versus Udwara, the respondent said a party relying on documents as part of his case just specifically relate each of such documents as part of his case in respect of which the document is tendered. The rationale for the judicial attitude is that the court cannot be saddled with the responsibility of relating each of the documents or bundles of documents tendered in evidence to aspects of the case of a party. This is because it is the duty of the party to do so for itself. More so, it will be an infraction of the right of fair hearing of the tribunal in the ambience of its chambers engage itself to guess which document relates a particular part of the case. Such a duty ought to be carried out in the open court. They said the tribunal should not have closed its eyes to the obvious defects or incompetence of the documents placed before it, or proceed to rely on such incomplete documents to speculate and find its favor of the appellant when the law is already well settled that incomplete documents are unreliable. They added that the tribunal was right in its findings that the appellant PW2, 3, 4, 7, 8, and 12 adduced evidence against the interest of the appellant during cross-examination, that there was no prior recording of some of the electoral forms, and therefore urged that the appellant's contention be discountenanced in its entirety as false and unfounded. The respondent said that it is instructive to note that after a detailed and painstaking review and consideration of the pleadings and evidence adduced before it, the tribunal found the following. 1. That the appellant did not tender all the polling unit result sheets and electoral forms used for the conduct of the Edo State governorship election to enable the tribunal determine the issues of majority of lawful votes as required by law. 2. That the provisions of Section 137 of the Electoral Act only applies to the issue of non-compliance but does not apply to the allegations or issue of failure to pool majority of lawful vote cast in election which constitute ground 2 in the matter. That the majority of the documents tendered by the appellants are not legible and do not bear the stamp of the Independent National Electoral Commission (INEC), which makes it difficult for the tribunal to ascribe any probative value to them. That the appellant did not call any significant number of witnesses to prove the allegations of failure to pool majority of lawful votes against the respondents, and the majority of the 19 witnesses called by the appellants were not eyewitnesses present at the polling units, and their testimony were mere hearsay evidence. 5. That the testimony of the patry of the 5 polling units agents of the appellants, even if mistaken as established as truthful, is grossly insufficient to prove the allegations of failure to put the majority of lawful votes against the second respondent in over 4,000 polling units in the Edo State in the September 21st, 2024 governorship election. 6. That the appellant's complaint in ground 2 of the petition is based on the hypothesis that ground 1 of the petition will succeed and result in the deduction of votes, but with the failure of ground 1, the ground is now academic as there is no vote proved to be invalid and liable to be deducted from those of the candidates. 7. That the appellants failed to prove their case as required by law. They submitted that the above findings and conclusions are not only sagacious and correct in law, but are also in congruence with existing judicial precedents of the Appeal Court and the Apex Court on the points in the issue. On issue number 3, the respondents want the Appeal Court to determine whether, based on the pleadings, evidence, and the applicable laws, the tribunal was right when it dismissed the petitions of the petitioner, having arrived at the conclusion that the petitioners failed to prove their case and that the same was liable to be dismissed. In urging the Court of Appeal to resolve the issue in the affirmative and to dismiss the appellant's appeal, they adopted their argument. They said the tribunal, having found for a fact and unassailable truth that the appellants dumped their document, failed to call direct oral witnesses evidence to prove their case, and that the ground 1 of the petition failed, thereby obviating the necessity of deducting any votes, and follows all the analysis of figures contained in the table and charts in the appellant's final written address and appellant's brief of argument are unproven, speculative, and baseless. They submitted that the appellants have woefully failed to demonstrate the existence of any error in the judgment of the tribunal, and there is no basis for faulting the judgment of the tribunal. They said the tribunal thoroughly scrutinized the pleadings of evidence of the parties and came to the correct conclusion of the facts and law that the appellants did not prove their petition against the respondents. The position of the law is well settled that evaluation of evidence falls squarely within the province wherein the trial court is dominant, and accordingly the appeal court traditionally accords prominence to the evaluation of evidence undertaken by the trial court and will not lightly interfere with the same nor disturb the findings of fact of the trial court. The respondents urge the appeal court to resolve accordingly against the appellants. Investigation revealed that the tribunal has transmitted the records of court to the Court of Appeal. And now that that has been done, it is expected that the President of the Court of Appeal will constitute a panel, and the panel will then communicate a date to parties for the pre-hearing. Before this Court of Appeal are for appeal as it relates to the Edo State governorship election. There are Action Alliance, Accord Party, the People's Democratic Party, and of course, the cross appeal by Governor Monday Okpewolo. From the Court of Appeal here in Abuja, the nation's capital,